and legal context has changed.
Chris Hipkins.
Thank you, Mr Chair. Mr Chair, I'm only going to be very brief because I think the issues on this bill have now been well traversed on both sides of the argument. I've listened quite carefully to the arguments put forward by the Green Party and the Māori Party, and while I accept that many of the issues that they're raising are genuine issues, they're much wider in my view than the bill as it stands at the moment. I think it's really important that members make themselves familiar on the back page of the bill with 34A, which makes it very clear the circumstances on which a young person's particulars are able to be kept, and basically it means that in all of these cases, it's accepted that the young person has done whatever it is that they've alleged to have been done. I think that's really, really important that we make that really clear. The police will not be keeping the photographs and the fingerprints of young people who are found to have done nothing. They won't be keeping them. That's really, really important, and I don't think that was clear from some of the contributions that we've seen from those arguing against the bill. It will only be if the case is accepted that those things will be, the records will be kept. And I think it's also really important that we acknowledge, particularly in the case of 34AD, where somebody is discharged without conviction, these are the young people that are probably at the highest risk of reoffending. And so making sure that the police can identify them, having that information readily available to them, I think is really important. So I've listened carefully to the debate. Ultimately, the change in the law was not intended. The responsible thing for Parliament to do is therefore to revert to the status quo. If members feel strongly that the status quo is wrong, then there are opportunities for them to bring a bill to the House to change it. But simply legislating to protect a mistake is not the way to do it.
The question is that Part 2 stand part. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
57 votes in favour.
New Zealand Labour.
42 votes in favour.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Māori Party.
3 votes opposed.
Progressive.
1 vote in favour.
United Future.
1 vote in favour.
Mana. Honourable Chris Carter. Any other votes?
Members, the ayes are 106, the noes are 12. Part 2 will stand part. We now move to the clauses. The question is that clauses 1 to 3 stand part. The question is that clause 1 stand part. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote called for. Ask the clerk to conduct a party vote.
New Zealand National.
57 votes in favour.
New Zealand Labour.
42 votes in favour.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Māori Party.
3 votes opposed.
Progressive.
1 vote in favour.
United Future.
1 vote in favour.
Mana. Honourable Chris Carter.
1 vote opposed.
Members, the ayes are 106, the noes are 13. Clause 1 will stand part. The question now is that clause 2 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. The ayes have it. The question now is that clause 3 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. I will report this bill without amendment.
The House is resumed. Mr Chairman.
Mr Speaker, the committee has considered the Policing, Storage of Youth Identifying Particulars Amendment Bill and reports it without amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. As many of that opinion will please say aye. Aye. To the contrary, no. The ayes have it. This bill is set down for third reading forthwith. I call the Honourable Minister Judith